Good evening, everyone. So for tonight, we will be discussing about the Judicial Affidavit Rule. Okay, what is this Judicial Affidavit? Kaning mga affidavit, like this affidavit contains all your statements as a witness, as a complainant, okay? Diha na nato makita og unsay atong mga statement. The lawyer will be asking you things, and then ang imong answers will be indicated in that affidavit, okay? So let's start. Section 1 of the Judicial Affidavit Rule, scope of application. So when we talk about the scope of application, this rule shall apply to all actions, proceedings, and incidents requiring the reception of evidence before all courts. When we say courts, this includes the MTC, MTCC, municipal trial courts and cities, the municipal trial courts, the metropolitan trial courts, and the rest of the courts. Also, this includes the RTCs, the regional trial courts, or also the courts for the Sharia district courts. And yes, as you can see here on the slides, it is stated in there, all courts are included here. This applies to all courts. Next, submission of the judicial affidavits and exhibits in lieu of direct testimony. So the parties shall file with the court and serve on the adverse party. So what will happen? You, as a lawyer, or the lawyers will file with the court the judicial affidavit. And of course, you have to copy furnish the adverse parties or the defendants. Okay. And what will happen if you have an attachment for it, like documentary or object evidences? Then if there will be an attachments or the evidences will be attached onto it, you have to attach it as an exhibit A, B, and C, and so on or so forth, in case you are the lawyer for the complainant or the plaintiff. When you are actually the lawyer of the respondent or the defendant, then you have to use exhibit no and number it 1, 2, and 3, and so on. Okay, then you have to submit this judicial affidavit not later than 5 days before the pre-trial or preliminary conference as ordered by the court. Next, evidentiary documents. Does it need to be original or not? You must warrant in your GA or judicial affidavit that the copy or reproduction attached to such affidavit is a faithful copy or reproduction of that original. In addition, the party, you have to, for the parties, you have to bring the original document or object evidence for the comparison during the preliminary conference. When there is already the pre-trial session, you have to bring all the original documents and present it to the court, because they are actually obligated to compare the copy and the original document. Okay, this of course, this is without the prejudice to the introduction of the secondary evidence in place of the original when allowed by these existing rules. Next, for the section 3, contents of the judicial affidavit. What are in the judicial affidavit? Okay, first rule, the judicial affidavit shall be prepared in the language known to the witness. If Bisaya si witness na to, of course, it must be prepared in Bisaya if in case di siya kasabot of English. But if the judicial affidavit is not written in English or Filipino, you have to translate it. You have to submit it accompanied by a translation in English or Filipino. And what are the contents? First, of course, it must have the name, age, residence, or business address and occupation of the witness. The second one, the name and address of the lawyer who conducts or supervises the examination of the witness, and the place where the examination is being held. Kay ma-technical man ka na, if in case mo attest ka dito that this was actually the examination was held here, but then later on they will find out that the what day siya katutol atong place kay imong gisulti dito. Third content would be the statement that the witness is answering the questions asked of him, fully conscious and he does not so under oath, and that he may face criminal liability for false testimony or perjury. It must be stated in there na Ang witness only answers what was the questions asked, fully conscious, kibaw siya kung siyang gansiran, and it must be under oath. Otherwise, he will face criminal liability or false testimony or perjury for that one. So next would be the questions asked of the witness and his corresponding answers, consecutively numbered that first, show the circumstances under which the witness acquired the facts upon which he testifies. Yun sa niya pagkaibaw, all the facts must be stated there. Elicit from him those facts which are relevant to the issues that the case presents, and identify the attached documentary and object evidence and establish their authenticity in accordance with the rules of court. So the signature of the witness over his printed name, it must be in the judicial affidavit, and of course the jurat with the signature of the notary public who administers the oath or an officer who is authorized by law. Jurat is signed by a notary public or a lawyer. Okay, this is the sample of the jurat as you can see in the screen. Fourth is the sworn attestation of the lawyer. The GA or judicial affidavit shall contain a sworn attestation at the end, executed by the lawyer who conducted or supervised the examination of the witness to the effect that he faithfully recorded or caused to be recorded the questions he asked and corresponding answers that the witness gave, and neither he nor any other person then present or assisting him coached the witness regarding the latter's answer. So, what would be the effect if magpatuyang si lawyer o mag-sign si lawyer with nga tinuod to, although it's not tinuod. So the effect would be a false attestation shall subject the lawyer mentioned to disciplinary action, including disbarment. So if that can be proven, the lawyer can be disbarred. Anyway, that is the sample of the sworn attestation of the lawyer. Section 5, the subpoena. If it entails government employees or official or the requested witness who is neither the witness of the adverse party nor a hostile witness, and just what happened if dili siya? Without justification, they will decline to execute a judicial affidavit. The court, the requesting party may avail himself of the issuance of a subpoena. Okay? Magpakuan sila og subpoena ad testificandum. The rules governing the issuance of a subpoena to the witness in this case shall be the same as when taking his disposition, except that the taking of the judicial affidavit shall be understood to be an ex parte. Section 6, offer of and objections to testimony in judicial affidavit. Okay, the party presenting the judicial affidavit of his witness in place of direct testimony shall state the purpose of such testimony. What is the purpose of taking this testimony? It must be stated in the judicial affidavit. So the adverse party may move to disqualify the witness on the ground of inadmissibility. Okay, next. Section 7, examination of the witness. So, of course, you have the right, as a lawyer, you have the right to cross-examine or redirect your own witness. The adverse party have the right to cross-examine the witness based on what was written on his judicial affidavit. And you also have, you as a lawyer, you also have the right to redirect your own witness to check or to determine whether his credibility or the to check on the truth of his testimony. Okay, so whatever findings there will be, the court will actually resolve that issue in there. Next, section 8, oral offer of an objection to exhibit. Upon determination of the testimony of his last witness, a party shall immediately make an oral offer of evidence. Okay, after presenting your last witness, you have to immediately make an oral offer of evidence of his documentary or object exhibits, piece by piece in their chronological order, stating the purpose or purposes for which he offers the particular exhibits. Next, after each piece of exhibit is offered, the adverse party shall have shall state the legal ground for his objection. Why would you object? What is the legal ground for the objection? Okay. Next, since the documentary or object exhibit form part of the judicial affidavits that exhibit and authenticate them, it is sufficient that such exhibits are simply cited by their markings during the offers. Okay. And the rulings dispensing with the description of each exhibit. Section 9, application of the rules to the criminal action. This is very important for you as a criminal students or future police. This rule shall apply to all criminal actions. Only where the maximum of the imposable penalty does not exceed 6 years, where the accused agrees to the use of the judicial affidavits, irrespective of the penalty involved, or with respect to the civil aspect of the actions, whatever the penalties involved are. And of course, the prosecution shall submit the GAs of the witness not later than 5 days before the pre-trial, serving copies if the same upon the accused. And then, okay, you have to take note that no further judicial affidavit, documentary, or object of evidence shall be admitted at the trial unless allowed by the court. So, if the accused desires to be heard on his defense after receipt of the judicial affidavits of the prosecution, he shall have the option to submit the GA as well as those of his witnesses to the court within 10 days from the receipt of the affidavit and serve a copy of each on the public and private prosecutor, including the evidences. Next, Section 10, what will be the effect of non-compliance with such rule for the judicial affidavit rule? The party who fails to submit the required judicial affidavit and exhibits on time shall be deemed to have waived their submission. The court may, however, allow only once the late submission of the same, provided the delay is for a valid reason, would not unduly prejudice the opposing party as well, and the defaulting party pays a fine of not less than 1,000 pesos nor more than 5,000 pesos at the discretion of the court. So that's all for today. Thank you.